House Bill 696, establishing a protective order for vulnerable adults. Representative Cushing will present the bill.
Thank you. Want to close that door? Thank you, Madam Chair, members of the committee. For the record, I'm Representative Ray Cushing from Rockingham, District 21, the town of Hampton, and I'm here in support of House Bill 696. In my family, my 93-year-old mother has dementia. And those of you who have family members who are suspect or of that disease know how incredibly painful it is to watch someone forget who they are. I also have a brother-in-law who's 56 years old who has Down syndrome, who also now has with that dementia. My mother, my brother-in-law are, by any objective standard, vulnerable adults. And what this language, what this bill is designed to do is to provide a mechanism by which vulnerable adults can have protection so that they don't get their lives ruined, they don't get their finances strained. 696 may be very familiar to members of this committee because we passed the same bill last year. It passed the House, went to the Senate. It ran aground in the Senate and didn't make it. But this is a piece of legislation that is one of a series of laws that have been initiated over the past 3 years to deal with our elderly and vulnerable population in the state. I know there are people here who will testify afterwards that will explain in greater detail the challenges that we face in New Hampshire as the state with the second oldest population. As we know, this passed the House. I know our purview as members of the Criminal Justice Committee are to take a look at the appropriateness of the fines and penalties in this. And I will just simply say at the outset that this language is modeled on the language that we have in this state that we've had in place to protect victims of domestic violence. And it includes a mechanism by which a person or an advocate for that person can go to a district or superior court, can seek a protective order, and that will be issued by the court. There's a lengthy mechanism in here that explains, that provides for due process for individuals and notice to people. I will just simply say that the penalties in this are consistent with the penalties for violation of our domestic violence protective order. And I think that we ought to be as cherishing of elderly and vulnerable people in our society and in our state as we are of those who find themselves in a situation where they're victims of domestic violence. And so to be consistent, we should pass this bill the way it's been introduced. And with that, I'll take questions. Or
Any questions?
Thank you. Oh,
Representative Burke.
Thank you. On page 2, line 14, it says vulnerable means that the physical, mental, and emotional ability of a person, et cetera, et cetera. Who is making that decision? Is it a medical doctor or is it the courts?
It would be, when in considering what, this would be a finder of fact, but I assume it would be based upon medical and other evidence. This is the definition. It would be a court, if considering issue of protective order, would make a determination if this person met the definition of vulnerable under Chapter 173D.
Follow-up? Yes, thank you, Madam Chairman. And thank you for your testimony. But I don't see in here where it says that, who is going to make that determination. I guess You know, if I'm missing it, I apologize.
Yeah, this is simply definitions. If you go through, you'll look at the jurisdiction and venue, so it's either the district court or the family court, or the circuit courts that would do it, or could go to another court, and that there would be the proceeding would be commenced, and then it would be the court itself, the court being a judge, would make the determination if this law was applicable.
Okay.
It's the same person makes decisions about all of our laws. It's the courts ultimately.
Thank you.
Yes. Raise your hand, Joe.
Thank you. And thank you for taking my question. On page 3, lines 16 and 17, essentially this says that the court will not be bound by the technical rules of evidence. Is there any benefit to the court not following the rules of evidence?
Again, I think this mirrors the language that's in the domestic violence statute, so I don't know whether there's a benefit or not.
Hello? Go ahead.
Do you feel that it's a good idea for the court to follow that, maybe from a reliability perspective, to follow the rules of evidence?
You know, I think that that the court is capable of figuring out what is the appropriate method by which this chapter should be implemented.
Yes, Representative Field.
Yeah, thank you, Madam Chair. Representative Cushing, thank you. I was just curious, you mentioned that the Senate killed
Yes.
this bill last time. Do you know what the difference is between the two bills, why this one is better than the last one?
I thought last year's was fine. I think this year's is fine.
Well, that follow up. But you don't know the difference between the two bills, what makes it better than the other one?
Well, I would say to the extent that this bill, a change that has been made is there's a provision of this bill that I think has drawn a fair amount of attention, is that a judge may find that it may find, if appropriate, that the defendant would surrender the firearms as part of the protective order. And this bill is the previous version. It was a mandatory part of the order. In this version, it is it's up to the discretion of the judge. It is not an automatic something. Does that make sense? I mean,
Representative Field.
On page 6, on line 5, at the end of that sentence, it's the first sentence. The court makes a specific finding that it's necessary for the protection of the plaintiff, issuing an order directing the defendant to relinquish to a police officer any and all firearms and ammunition in the control, ownership, or possession of the defendant, or any other person. Why any other person?
for the duration of the protective order.
Yeah, but any other person, they may not be involved with that.
Well, I presume that the court would make a specific finding that it would be necessary and would make a determination that if for instance, if a firearm was not under the control of a defendant, but in the control of someone else, that could include that the judge would be able to include in the order.
Thank you. But just on that point, wouldn't that person or the other person not have standing in this civil case to challenge that order? So if that other person was ordered to surrender something pursuant to this order, they're not a named party to the order itself.
I'm not sure if I understand the question. I will just simply say an order of the court is a specific order that that anybody's obligated to carry out.
Yes.
If there's if there's an order that for whatever reasons enjoins people from going onto public property because there's toxins on that property and it might create a public health hazard, you don't get standing to challenge that order, I don't believe, unless you're directly impacted by it. If you were impacted by this order, obviously you'd have a way to, you'd be able to challenge it.
Yes.
Okay. I guess my concern is that you have a petitioner and a respondent, but the person being ordered to surrender their property or their firearms or ammunition is not the respondent. So I guess my concern is that they're not a named party in the lawsuit. They're not even necessarily going to be served with this order.
Well, there's other people, there's other instances, you know, it's not just in this instance, it's if someone has control of somebody else's property. If you're a, you know, if you're a bank and you're ordered, part of the order says that, you know, that the funds that rightfully belong to the victim who is seeking the order, if those are not in the control of the person who, against whom the order is being sought, but they're in the possession of another party, such as the tellers at the bank, or such as, you know, I'll use that as an example, that still would be applicable to the bank, even though the order was against another, against the respondent, because then that would be an instance where the bank would actually have controls over the money that the defendant is seeking to steal from the, or deprive the victim from. Does that make sense?
I understand. I disagree with you.
Okay.
Thank you, Madam Chairman. I guess there's two questions. There's one, how would, you know, once the order is done, how would the individual, you know, get his firearms back?
Ask for them back.
Excuse me?
Ask for them back. I assume that when the order is, should there be an order that that would talk about the order that covered any activity that the defendant should engage in, that when the order was no longer in effect, the defendant would be free to go about their business.
If this is mirroring the domestic violence, if I understand right, you know, through people that have told me, that they have to petition the court, which is an added benefit, or added cost, not benefit, added cost, to retrieve their firearms. You know, why can't we just put that in here, you know, in an amendment saying that, you know, would you support an amendment that just says, you know, if the order's lifted, then you automatically go back to normal?
I'd certainly talk about it. You know, I don't support language unless I take a look at it, Representative, but I mean, that's something, I'm not quite sure I understand what the concern is. I'm trying to be helpful, and if there's a concern and there's a way that your concern can be addressed that's consistent with the policy in here. But again, I realize that I realize we're supposed to be talking about the penalty phase, but I understand that sometimes it's the underlying bill itself needs to be taken a look at in order to really understand the appropriateness of the penalties involved. But.
Well, if I may, one last follow-up. Yeah, this is about the penalties.
And that would.
Let's say you, for some reason, had a protective order against you. So you gave up all your firearms, your steak knives, and everything else that you have to give up. Me being a nice guy and I like you, I'm going to come and visit you. So what happens if I'm there and I have my firearm? You know, am I subjected to, you know, because it's, you know, it's pretty broad, you know, it's of who has to give up their firearms that's living, you know, with you or, you know, in the home. You know, would I be in violation, or anybody else be in violation if by chance they had a firearm next to you?
Well, respectfully, I disagree with your premise that it's pretty broad. I think this bill is very narrowly drawn, and that what you would have a specific order, and it would be the language of a specific order that was issued by the court that would be controlling in that situation.
All right, thank you.
Representative Wilson?
On page 7, line 4, it talks about the remedy. If either party wishes the defendant to be excused from any provisions of an order of protection, the remedy is to petition the court for modification of such order. And would that also not be a way of getting the firearms back?
Yeah.
So you know.
Thank you, Representative.
Thank you very much.
There are a lot of people who want to speak today, so if you would keep your testimony to 3 minutes.
Croc TV.